I'm Velshi with MSNBC. The Supreme Court released its opinion in a landmark gun case. In a 6-3 opinion by Justice Clarence Thomas, the court held that New York's law requiring anyone seeking a concealed carry license to demonstrate that they had proper cause for the license violates the Second Amendment. Joining me for a more perfect union is Jeffrey Rosen, president and CEO of the National Constitution Center. Jeff, obviously this one got buried because we've been talking so much about the abortion decision, but this decision expands the Second Amendment right to bear arms to include outside the home. Help us understand this opinion and what it means for gun rights and gun control measures, as well as legislation like assault weapons bans.
Well, it's a tremendously important decision, Ali, and it's very important that viewers read the decision themselves, both the majority opinion and the dissent. I'm going to summarize both of them, and then I'll give you a website for excerpts from the decision. So the majority strikes down, as you said, New York's may issue concealed carry regime, which requires a special need for a concealed carry license. And in doing so, the court said that under the Second Amendment, you have the right not only to keep a gun in your home, but also to carry a handgun for self-defense outside the home. And in his majority opinion, Justice Clarence Thomas focused on the history and tradition of the Second Amendment. Basically, he asked, does historical precedent similar to the New York law exist before, during, and even after the founding era? And Justice Thomas's answer is no. He said, we find no such tradition in the historical materials. In a very vigorous dissent for the three liberal justices, Justice Stephen Breyer criticized Justice Thomas's history and tradition approach. He said judges aren't historians, and it'll be too easy for them to pick their friends out of history's crowd. In other words, to cherry pick the historical record for evidence that supports their views and ignore evidence that doesn't. He also worried that this historical approach would prevent states from flexibly adapting to new procedures posed by new technologies. He had one very memorable line. He said, laws addressing repeating crossbows, launce-gaze, dirks, daggers, skeins, still ladders, and other ancient weapons are of little help to courts confronting modern problems. So what does this mean for gun control in America, as you asked? Well, for starters, New York and 7 other jurisdictions with may issue regimes, these discretionary regimes, which represent about a quarter of the country's 84 million people, will have to switch to shall issue regimes, which means that applicants will get a concealed carry permit as long as they meet the criteria. Under Justice Thomas's approach, it is still possible for states to ban dangerous and unusual weapons and to ban guns in sensitive places. But what counts as a dangerous and unusual weapon is up for debate. And in fact, courts are already beginning to divide about whether or not assault weapons bans are permissible under Justice Thomas's approach. Ali, as I said, it's very important that viewers read the majority opinion and the dissent on their own. A great place to start is the National Constitution Center's We the People podcast, where we did an excellent debate about the Second Amendment decision. And we're also posting excerpts from the majority opinion and the dissent on our website, constitutioncenter.org.
Jeff, thanks as always. Jeffrey Rosen is the president and the CEO of the National Constitution Center. Be sure to follow Jeff and the National Constitution Center on Twitter @RosenJeffrey and @ConstitutionCTR.